This is Barry Zalma speaking for Claim School Incorporated's blog, Zalma on Insurance. Today we speak about the problem with claims-made policies and why notice to insurers of a potential claim controls which policy and which policy year provides coverage, especially if it is possible to show a meaningful linkage between the notice and a class action filed by the Securities and Exchange Commission. The Supreme Court of Delaware, en banc, dealt with an insurance coverage dispute where Alexion Pharmaceuticals, Inc. appealed a decision from the Superior Court of Delaware, with every member of the Supreme Court participating. In the case entitled In Re Alexion Pharmaceuticals, Inc. Insurance Appeals, the Supreme Court of Delaware on February 4, 2025, resolved the dispute over which insurance policy applied to which claim. The issue before the Supreme Court was whether a Securities and Exchange Commission investigation disclosed to Alexion's insurers is related to a later securities class action brought against the company. The Superior Court found that the two were unrelated. The Supreme Court reversed the decision, finding that the securities class action arose out of the circumstances disclosed by Alexion to its first tower of insurers. Alexion Pharmaceuticals develops therapies for people living with rare disorders. Alexion was insured under two claims made director and officers liability insurance programs covering different periods. The first program provided $85 million of coverage for claims made between June 27, 2014 and June 27, 2015, Tower 1. The second program provided $105 million of coverage for claims made between June 27, 2015 and June 27, 2017, Tower 2. The two towers consist largely of the same insurers located in the same coverage layers, and both insurers are structured as ABC directors and officers policies covering securities claims against the company. Each tower is composed of a primary policy and follow-form excess policies. The insureds first became aware of facts or circumstances which may reasonably give rise to a future claim covered under the policy, and if the insureds give written notice to the insurer during the policy period, a description of the anticipated wrongful act allegations must be provided. Solaris is an orphan drug developed by Alexion that treats rare genetic disorders. In 2017, Solaris had about 11,000 customers worldwide. Solaris had a retail price of $500,000 to $700,000 for each patient. The SEC investigation order raised possible violations of the federal securities laws. On June 18 of 2015, Alexion sent its Tower 1 insurers a notice disclosing Alexion's receipt of the SEC subpoena, and also stated that the SEC subpoena seeks information related to Alexion's recalls of specific lots of Solaris and related securities disclosures. In July of 2020, Alexion settled with the SEC for about $21.5 million. On September 12 of 2023, Alexion settled a securities class action for $125 million, more than the available limits. It, of course, sought coverage from the policy with the highest limits. The Supreme Court agreed that a meaningful linkage is the appropriate standard of comparison, and Alexion's 2015 notice was not a claim. Chubb accepted Alexion's 2015 notice as a notice of a circumstance that may give rise to a claim. The Supreme Court concluded that the securities class action was meaningfully linked to the wrongful acts disclosed in the 2015 notice. Both involved the same alleged wrongdoing, and the securities class action alleged the same wrongdoing investigated by the SEC and disclosed by Alexion in the 2015 notice. Both SEC investigations involve the same wrongful act, Alexion's grant-making activities. A meaningful linkage exists, therefore, between the securities class action and the SEC investigation as disclosed by Alexion in its 2015 notice, and under the policies of both towers, the securities class action claim is deemed to have been first made at the time of the 2015 notice that was received by Chubb during the Tower 1 coverage period. Therefore, coverage is under Tower 1. Applying the prior notice exclusion provision of Tower 2, no available coverage exists under Tower 2, and therefore the judgment of the Superior Court was reversed. In my opinion, claims-made policies require reports of potential claims, because if you don't report, you could lose coverage for a later claim. Alexion told its insurers about the potential claim under its Tower 1 and was entitled to coverage for the suit to follow. The prior notice exclusion eliminated coverage for Tower 2 because it came into effect after 2015 when the first notice was given. Parties and judges must read the policy wording before making a decision on coverage, and since there was a meaningful linkage between the notice and the actual claim, coverage was available only under Tower 1 and not Tower 2. This video was adapted from my blog, Zelma on Insurance, which is available free to anyone who clicks on the URL zelma.com/blog. You can subscribe to the blog, and if you do, you'll receive notice of every blog posting, usually 5, sometimes 6 a week, and you'll gain access to the more than 4,950 blog postings. You can also subscribe to these videos on YouTube and rumble.com. They're free. And if you do, I'd appreciate you also tell your friends and colleagues about the blog and the videos so that they too can subscribe. And if you're interested in further detail about insurance, insurance claims, insurance law, and insurance fraud, please consider subscribing to my Substack publications. Thank you for your attention.